Good morning. We are going to discuss today the relationship between the independent contractor and the owner. In the previous lectures, we have seen vicarious liability and we have also seen the relationship between the master and the servant. How the master is liable to third persons for the torts committed by his servant. Now here we are going to see the relationship between the owner and independent contractor. First of all, we will understand who are they. We'll take an example. We have a plot and we want to construct a bungalow. So what we do, we first meet an architect, we tell him our needs and he prepares a plan for us, a plan for a prospective bungalow. So after that, we give that plan to a contractor, a civil engineer who is going to construct a bungalow for us. So he is an independent contractor and we are the owner. Independent contractor is a person who is going to give you the given result, who undertakes to produce the given result without being interfered by you. He is an independent contractor. We can't control him. We can't supervise him. He is having his own discretionary powers. He will appoint his servants, he will appoint the mercenaries and all, and he will take the decision. He will tell you, okay, in these days or these months, I am going to give you the given result, the bungalow will be constructed. You should not interfere. We will not interfere with him in his work. If we interfere, what he'll say, okay, better you construct yourself. I am a civil engineer, I am a contractor, I will take my own decisions. So you appoint him. You can remove him also. You pay him. These are the three essentials for a servant also. But here also the three essentials are there. But the fourth thing which is there in between the master and the servant, that is not there in the owner and independent contractor. And that is what a master is going to supervise. The servant is under the control, under the direction, under the direct control of the master. But here the independent contractor is not under the direct control of the owner. This is the difference between independent contractor and owner. So okay, we are the owner of the plot. That contractor is going to construct a bungalow for us. We are not going to interfere. So if his servants are going to do certain things and certain wrongs, some third person is affected, the third person is at loss, then we are not liable. Law says you are not allowing the owner to interfere in your work, na? So you yourself are liable then. So the independent contractor is liable for the wrongs done by his servant, not the owner. This is a general rule. I have told you in the first lecture only that law is what? Made by exceptions. So here also many exceptions are there. In the exceptional cases, what happens? The owner is liable for the wrongs committed by the servants of the independent contractor or the independent contractor. So these are the exceptional circumstances where the independent contractor is not liable to third parties, the owner is liable. And we'll repeat and we'll go further. The general rule is the independent contractor himself is liable for the wrongs committed by his servants, not the owner. This is a general rule. But in special circumstances, the owner is liable. The independent contractor is not liable. Now, when the owner is liable, we'll see the exceptions. Now, the first is where the thing contracted is itself an unlawful act. Means I appoint an independent contractor to do some unlawful act. So myself is liable, not the independent contractor. The independent contractor, he checks everything. He feels that this is lawful and all. He thinks this is lawful. I am having authority, but it is not. I am doing a fraud against the independent contractor himself. So if third parties are at loss, then the owner is liable. Therefore, the thing contracted itself is unlawful. The owner is liable. Okay. The legal duty or the implied warranty is been given by the owner to somebody, then he himself is liable. See, if I promise you to do something, I'll do it for you. I have told, don't worry. I give you a guarantee. I give you a warranty. it will be performed in a perfect manner within this time only. Or if it is a legal duty of mine to do it, but actually what happens, I appoint a contractor and I am going to do that work through the contractor. You don't know anything about that, and that independent contractor does it wrongly, or his servants do some mistake or negligent act, then you are at loss. What you will say? You are liable. You gave us the guarantee, you have given us the warranty, you are under the legal duty, therefore the owner is liable here. Therefore the next exceptional circumstances is what? When the owner is under legal duty to perform the work, or if he has given an implied warranty to do the work, then for third persons, in front, who is there? In front the owner is there, the employer is there, therefore he will be liable. Okay. The other circumstances is that when I appoint or the owner appoints an independent contractor, but he is not a competent person, means I know I am going to perform some work for you, but through independent contractors only I am going to do it. But at the time of appointment, I have to check whether the contractor is efficient, is going to do the work in a proper manner or not, efficiently or not. Therefore, if I appoint an independent contractor who is completely incompetent, so what will happen? He is incompetent. Therefore, the work will be not performed in a proper manner. Na? Therefore, here also the owner himself is liable. Okay, we have seen a topic, strict liability. The principle of strict liability says that when somebody brings something on the land and it escapes and causes injury to the other, then the person who brought the thing, he is at his own peril, therefore he is liable. So in Reland versus Fletcher, what happened? A tank was to be constructed in the person's land, and he appointed independent contractor. His servants have done the act negligently. Loss is caused to third person. For third person, the independent contractor is not liable. The owner is liable, because the third persons are going to tell, we don't know how you are going to do, from whom you are going to do, or whose servants are going to do. We know that you have brought the thing or you have constructed it, therefore you are liable. Therefore, wherever the concept of strict liability or the principle of strict liability is there the owner is himself liable, not the independent contractor. The next is, we are having an act called as Workmen's Compensation Act. Now it is called as Employee Compensation Act. The main owner of the factory is called as the principal employer, and if he appoints contractor and that contractor brings his servant for doing certain work and something happens to them or to third person, the factory owner, that is the principal employer, will be liable, because there are certain provisions like that which are made in the Employee Compensation Act. Okay. Now the last exception we are going to see, which is very important, because the main concept is what? As the owner is not interfering into the work of the independent contractor, the owner is not liable. That is a basic thing. We are not making the owner liable because he is not interfering into the work. The independent contractor is liable as a general rule. But if the owner interferes, then if the owner is interfering, if he is keeping control over the work of independent contractor, then the owner himself should be liable. If I am going to go to the site every day, I am going to control the machineries, I am going to tell all his servants, do the work like this, do the work like that. So what happens if something wrong occurs? The independent contractor will tell, see, the directions were given by you, so you yourself are liable. We'll take one case. The name of the case is Burgess versus Gray. A drain was to be constructed. Therefore, what happened? The owner appointed independent contractor. He has given the warranty and all. He is going to do the work in a proper manner. He has told it to the owner. But what the owner does, he interferes into his work. Every now and then he interferes. He keeps control over his work. And while doing the work, the contractor has left a heap of gravel on the road, and he is going to remove it also. The heap of gravel is to be removed. The contractor has undertaken that. But the owner comes, and what the owner tells the contractor, you better go away, I'll remove it. And he does not remove. The contractor goes away, and the owner who has taken the undertaking that I will remove the gravel from the road, he does not remove, and the plaintiff, he slips from that gravel and injuries are caused. Therefore, the plaintiff has filed a case against both of them, that is the owner and the independent contractor. Now here the owner is telling the court, the gravel was not put on the road by me, but the independent contractor proved that yes, the gravel was there for the work of the drain. That gravel was brought by the independent contractor, but when he was going to remove it, the owner told that I will remove. So I thought he'll remove it. He must have removed it. Therefore I went away. So here the owner will be liable. Therefore the owner or the principal employer, when they directly interfere, control or interfere into the discretionary powers of the independent contractor, the owner is liable, the independent contractor is not liable. Generally, independent contractor is liable. We'll just repeat. Independent contractor is liable for the wrongs done by his servant, not the owner. But sometimes, vicariously, in certain circumstances, the wrongs done by the independent contractor or his servant, the owner or the principal employer is liable. We have seen two different relationships. There are actually 6 relationships. We have seen 2 relationships where vicarious liability exists. That is master and servant, and the owner and the independent contractor. Okay, bye bye. See you in the next video.